Well, good morning, everyone. This is the resumed hearing of Stubbs and others against the Queen, and we're continuing with the submissions of Mr. Knox for the respondent in the Stubbs and Davis appeal. No, Mr. Knox.
My Lords, can I just make just make 3 points, which I just want to clarify on what I was saying on Thursday. And the first is this. I said on Thursday, confidently, that Fergus was an identification case where the Court of Appeal had overturned the conviction because of a hopeless identification evidence generally, but it wasn't actually an identification parade case. My Lords, what I didn't realise when I said that is that there are 2 Ferguses. The Fergus I was referring to was Ivan Fergus, which is at tab 30, 4485. So that's what I was talking about then. However, there's also another Fergus, which coincidentally was decided by the Court of Appeal shortly before Ivan Fergus, which is at tab 29, at page 4482. And that is a doc identification case. And my Lords, there's a short report from the Criminal Law Review, but I can summarise it. It was held that where a complainant has seen an assailant only once, or possibly on a few occasions before, that might well be treated as an identification, not a recognition case, and that identification through a name only by hearsay was, quote, almost equivalent, unquote, to a doc identification, and so have a parade. I think that must be the case that Mr. Fitzgerald was referring to, not the one that I was. Secondly, my Lord, I was asked towards the end of the afternoon a question by Lord Hamblin, which was, I'm not sure I fully understood actually at the time, thinking about the answer I gave, which was what direction should the judge have given the jury if they rejected Campbell's evidence that he had identified Stubbs at the parade? Now, my Lords, I accept this. Supposing that had been the jury's thinking, I accept that in theory the judge could have directed the jury that therefore they should treat Campbell's identification of Stubbs in the doc as a doc ID, because there wouldn't have been a prior identification at a parade. Now, but he would also have been entitled to give a countervailing direction to the effect that the dangers which militate against doc identifications might be thought not to exist in this particular case, because there's no doubt, A, Stubbs was actually at the scene, and the question was he one of the shooters? Secondly, Campbell did name Stubbs by name, or at least by die of Bridgeland Park, in his statement on the 30th of March, albeit as the man at position number 2, rather than as the man at position number 5. And thirdly, the judge could have reminded the jury that Campbell's evidence was that he recognised him anyway. So there would have been what you might call a counterbalancing direction, if there had been a direction that the jury should treat Campbell's evidence, doc identification as a mere doc identification. So, my Lords, I accept that, but I say that wouldn't have been of any avail or made any real difference, or any difference to the result. Thirdly, my Lords, and it's a related point, it is in my submission trite, but it's worth remembering that there is always an obligation, if a point is to be made in favour of the defence, there is always an obligation to put a countervailing direction, which the prosecution could put in answer to it. And there is authority for that in the bundles. I won't go through it, but it's in the case of Everard Nichols, at tab 48, the page begins at 4878, but the relevant page is at 4884, and a case, I think it's a judgment of Lord Staines. But in my submission, that's quite an important point generally in this case, because often what is said against the judge is he didn't make certain directions, to which the answer is, well, if he had given certain directions, then there would have been a countervailing direction going the other way. So what difference does it make in the end? My Lords, I think I finished off last time talking about the admission of the evidence and of the deposition of Scott. And my Lords, I made the point, which I submit as a fundamental point, is that the judge did take into account in admitting Scott's deposition and transcript that this was, as he put it, a doc identification case. So he's got that well in mind. So he's taken on board the relevant point. My Lords, I'm not sure if I made this point, but he also had well in mind that there were discrepancies between the deposition and the transcript, in particular about the time for which Scott said he had known or known of Stubbs. And the reference for that is at bundle 1, page 173, lines 26 to 174. I won't go there again, but he's well aware of that point. And then, my Lords, he takes the view that Scott's evidence cannot be let in unsupported, and I think that's where I finished off. And then, so he lets the evidence in. That's 174, lines 16 to 21. And, my Lords, therefore, he refuses to exercise his exclusionary discretion and lets in, my Lords, this is important just to note, he lets in both the deposition and the transcript of evidence. Both are let in at that point. That's 174, 16 to 21. And my Lords, by this point, it's also worth noting, an application had been made to exclude both the transcript of evidence and the deposition. And you can see that, I think, in the passages at page 133 to 168. There was a generalized attack on both. And in my submission, the judge was entitled, as a matter of law, to allow in the deposition on the basis that he did. And it's, my Lords, it's trite, but it is, in my submission, worth reminding myself of what the law is on this. And my learned friend, I think, referred to, but didn't take you to the board's judgment, I think my Lord Care's judgment in Max Tydo, which is at bundle 4 of the authorities, at tab 63, if I can dig up the page number, page 5164 is where the judgment begins, and this was a case in which the question of doc identification arose in the event the appeal was dismissed on conviction. And one can see the relevant principle, which is after a consideration of all the main cases up to that point, at 5172, and my Lords, I do rely on this in support of the judges admitting both the deposition and the transcript. And you can see paragraph 21, 5172. The board therefore considers that it is important to make clear that a doc identification is not an admissible evidence per se, and that the admission of such evidence is not to be regarded as permissible in only the most exceptional circumstances. So in other words, it's not one of those only in the most exceptional circumstances. It's a matter for what you might call a general consideration. The trial judge will always need to consider, however, whether the admission of such testimony, particularly where it's the first occasion on which the accused is purportedly identified, should be permitted on the basis that its admission might imperil the fair trial of the accused. Where it's decided that the evidence may be admitted, it will always be necessary to give the jury careful directions as to the dangers of relying on that evidence, and in particular to warn them of the disadvantages to the accused of having been denied the opportunity of participating in an identification parade, if indeed he has been deprived of that opportunity. In such circumstances, the judge should draw directly to the attention of the jury that the possibility of an inconclusive result to an identification parade, if it had materialized, could have been deployed on the accused's behalf to cast doubt on the accuracy of the subsequent identification. The jury should also be reminded of the obvious danger that a defendant occupying the dock might automatically be assumed by even a well-intentioned eyewitness to the person who had committed the crime. So, my Lord, that's the principle. And I'm just for the moment on the admission of the evidence as opposed to the summing up. But I say that there's no proper basis for criticising the admission of the deposition or the transcript. My Lords, my learned friend said in passing that I think a lot of witnesses seem to excuse their inconsistencies, including Scott, on the basis that they were frightened. My Lords, I respectfully submit it's obvious, but this type of case, this is a very serious murder in the sense that it was a public one. This was outside a nightclub early in the morning, 4 men shooting guns, or 3. It is entirely plausible that Scott would have been frightened. He was, after all, the victim of the attempted killing. Campbell's evidence, which is that I won't go to, but I've referred to it in our case. At bundle 2, 448, 8-18, he talks about the men firing guns just as they came outside the club. And that indeed is where, I'll come to this later, that indeed is where casings are found, just outside the club. And so, my lords, I submit, one cannot say that Scott's evidence or his explanation for his inconsistencies was so implausible that the judge should have excluded it. It's an entirely plausible reason. Now, my lords, there's just a footnote on this point about Scott and the deposition, and the transcript of evidence, which is this. After the judge's ruling, which I took you to, the deposition was read into evidence on the 21st of June at the trial. And then after that, Mr. Ducil, on behalf of Stubbs, asked for the transcript of evidence to be edited on the basis that the ID parade evidence should be excluded. You see that at page 200, in bundle 1, volume 1, sorry, page 251, line 5, to 252, line 25, and 256, line 13 to 258, 13. So Mr. Ducil says, I want, at that point, specifically, he makes a point that he wants the ID parade evidence excluded, but the judge rejects that at this point on the basis that he has already ruled on the point. And you can see that at page 257, lines 4 to 8. So in other words, understandably, the judge, having already considered the ID parade evidence point, when the point is revisited as a specific editing point, says, well, I'm not going to do that. I've already made my ruling. My lords, can I also add this? By this stage, of course, the deposition, forgive me, my lord. Yes.
Yes, Lord Burrows.
Can I just trouble you, Mr. Knox, to give me the reference for the deposition? We keep on getting references to the deposition. Can you just remind me where that is?
Yes, I think I can. It's in bundle, it's volume 1. That's to say where it's read out. My lords, the deposition is not, so to speak, in the record as a self-standing document. It's in the record as a document that's read out to the jury. And that, my lords, if I can, I think I've sort of marked it up. I'm just looking at my bundle, and I think it's read out by Mr. Seymour, and the actual evidence, you can see it is read out, I think, at bundle 1, 195 onwards.
Thank you very much.
So that's where it's actually read out. So it's read out before Mr. Ducil says he wants the transcript of evidence edited. And I submit it is a long point by then because the evidence has already gone in through the deposition. But more importantly, the judge has already ruled on the point in his earlier ruling. So, my lord, I submit, just for the moment, on the admission of the deposition and the transcript, the judge acted entirely correctly. He did not misdirect himself on the law, and indeed, I submit it was an entirely sensible decision. And therefore, there's no reason for interfering with the Court of Appeal's assessment of the point. I'll just give you the reference. It's at volume 9, page 3375, paras 126 to 127. My lords, that leads to the directions on Scott's evidence. The Court of Appeal held at volume 9, 3379, para 134, that no credible attack could be made on the judge's directions. And in my submission, that is right. If I can just go to volume 2, to the relevant part of the directions, they begin at page 572. And one can pick it up at line 13, where the judge points out that if a witness is picked out and accused at a parade, that enhances the weight to be placed on his evidence. And then he goes on to talk about Martian Scott's identification from line 19 to line 31. He gives the description of the identification. That's to say, it was a pure doc ID. Now, my lords, just pausing there for a moment. My learned friend, Mr. Fitzgerald, points out correctly at line 23, the judge says he was not given an opportunity. In other words, Scott was not given an opportunity, whereas perhaps what the judge ought to have said is that Stubbs was not given the opportunity of an identification parade. My lords, I accept that's right, but in the overall scheme of things, I submit it's a minor slip, and the chance of the jury being misled as to the overall point are nil. So I accept that the judge should have said that Stubbs was not given that opportunity, but I say nothing turns on that. And then line 32 of page 572 through line 16 of 573, the judge talks about the disadvantages, or rather the safeguards that are offered to an accused by an identification parade, held near at the time. It's a check on accuracy, and at line 11 and 573, the major disadvantages. And then line 17, he goes on to say what the risk inherent in an identification parade is, and that takes you down to line 31. And in my submission, there's nothing wrong with those directions whatsoever. They are very clear directions. And then even over as you get to the foot of the page, line 32, 573 to 574, the judge goes on to add, bear in mind any inconsistencies in Scott's evidence about how long he knew them and the reasons he's given for those inconsistencies, and then you must consider all the circumstances. It's for you to assess the weight. And in my respectful submission, those are entirely proper directions. I accept that the judge doesn't direct that the consequence of there not having been a parade is that Stubbs lost the opportunity of what you might call a positive non-ID. But again, my lords, I submit that's not sufficient to undermine the safety of the conviction. My lords, another point my learned friend made, I think in relation to Scott, is that the judge doesn't remind the jury that there was no opportunity to cross-examine Scott about the threats that have been made to him. And that is at page 5. My answer to that is that the judge does deal with the problems of just having transcripts or depositions at page 579 of his summing up. And you'll see at 579, line 22, the judge obviously has to be a bit careful what he says about transcripts of evidence, because this also applies to the evidence called on behalf of Mr. Evans from Miss Colebrook, because she too gave evidence only by way of transcript. But he says at line 22, the evidence of Martin Scott was read to you from a deposition given before magistrate at the preliminary inquiry on the previous occasion. You should bear in mind that this deposition evidence is not necessarily the same weight as evidence which has been tested before you by cross-examination in this trial. In assessing this evidence, you should take into account that the jury have not had the benefit of seeing the deponent nor hearing the evidence tested at trial. And then he goes on to explain the position in relation to the general rule about evidence having to be given orally, 580, lines 4 to 15. And then he deals with the position on the transcripts of evidence at 580, line 16 onwards. And then he concludes, line 28 on 580, you must therefore consider the evidence of Scott and Colebrook in the light of these limitations. only acts upon it if, having taken these matters into account, you are nevertheless sure that it is reliable. And then he goes on to talk about Scott's deposition and transcript. My lords, I submit those are entirely fair directions. My learned friend says he didn't draw attention to the point about threats and so on. The difficulty with that is that's a two-edged sword. The more the judge reminds the jury about threats and so forth, the worse things get. So I submit the judge was quite right to leave things as they stood, just warning the jury to be very careful, about the limitations, or in the light of the limitations, in deposition and transcript evidence. My lords, that deals with Scott's summing up, sorry, the summing up in relation to Scott. As far as the fresh evidence point is concerned, my lords, I hope I can deal with this briefly. I submit there is no basis at all for overturning the Court of Appeal's assessment. It's a classic Court of Appeal point, and it's not possible in my submission to point to any error of principle in their approach. The relevant passages begin at volume 9, 3380, para 136, and they continue to 3383, 147. I don't propose to read them all out. I think my learned friend took you to them the other day. But there are 3 points to note. First of all, they apply Benedetto, and that you get from para 144 at 3381. So they apply the right test. They turn their mind to the right test. Secondly, my lords, I submit they're plainly right when they say that there is no reason why the evidence couldn't have been obtained, at least by the trial in 2013. This is because Stubbs' own evidence was that he became aware of the point that Scott may not have been a police officer at the time of the offence in 2007. And that's the point they make at paragraph 141 at 3380. And my lords, that was plain from Stubbs' own evidence. And thirdly, my lords, they say, anyway, the evidence is ambiguous, and that's at 3382, 146. And I submit they're quite right to say so. If I can deal with that briefly, if you go to, I think, volume 9, 3341 to 5, I think, my lord, I may have a typo. I do apologise. My lord, perhaps one can pick it up from 3304. This is the affidavit of Superintendent Johnson. My learned friend took you to this, but I submit, my lords, it is clear from this that Mr. Scott was still employed by the police force as of January 1999. He says in paragraph 2, his date of discharge is given as 11th of January 1999, which was the anniversary date of his enlistment, having declined to be re-engaged. His final salary disbursement was 14th of May 1999, and I should have drawn your attention to this in the first paragraph, sorry, in the first sentence. He says he applied for disengagement on the 16th of March 1999. So he's obviously still employed on the 16th of March 1999. He can't be applying for disengagement if he's already left. And then they go on to make the point about the final salary. And then paragraph 3, that due to the process involved in re-engaging and disengaging officers, it's not unusual for there to be lapses of time before the conclusion of an engagement period and re-engagement, or disengagement at the end of an engagement period. My lords, I accept he doesn't actually say here precisely when Mr. Scott would have ceased being a police officer. We don't know, therefore, from this whether it was the 16th of March 1999 or sometime shortly after that. All we know is there's a final salary payment is made in 14th of May. My lords, at page 3307, you can see what you might call a summary of the relevant details or chronology. Now, my lords, what I say about this is the Court of Appeal was plainly entitled to find the evidence is ambiguous. we have this evidence, which taken on its own, suggests that it's in fact perfectly likely that Mr. Scott would still have been employed as a police officer at the 30th of March 1999, having applied for disengagement only on the 16th of March. I accept, on the other hand, the national insurance records suggest that in March 1999, his national insurance payments, contributions, are made not by the police force, but by the his security employers afterwards. But my lords, I submit nothing turns on that, and there's no reason to interfere with the Court of Appeal's findings. My lords, can I also make this point? It's a point we make in our case to which there hasn't really been an answer. Why is it said that Scott was lying when he said on the 30th of March he was a police officer? Because there's no doubt whatsoever from his own evidence that and it was quite clear to the jury, that on any footing, shortly after that, he had ceased to be a police officer. So where would all this evidence have gone before the jury? At the most, it would have gone to this effect. I put it to you, Mr. Scott, you were not a police officer at the 30th of March. You had already ceased to be, which he no doubt says, no, I was a police officer. And then it turns out that there's an issue as to when he'd ceased to be a police officer. But my respectful submission, it's very difficult to see what possible benefit there was to Mr. Scott in saying he was a police officer as at the 30th of March 1999, if in fact he wasn't, or indeed what serious inference the jury would have drawn from that. And likewise, I submit there's no basis for saying that that evidence is so significant as to undermine Scott's evidence, or indeed to amount to a reason for not admitting it. So I say nothing turns on that point. My lords, that leads me to the admission of the evidence of Mr. Higgs. And my lords, can I just summarise what I say in a series of propositions about this and then go to the evidence? My lords, this is, and forgive me, it's a slightly laborious exercise because I submit once again the key to understanding what happened is to look very carefully at what was put before the judge at the time. And the difficulty, I say, in a short compass with Mr. Fitzgerald's submissions is that they don't really focus on what the judge was being asked to do and the submissions being made to him. When you look at the submissions made to him, what he did in my submission was absolutely right and entirely understandable. But I summarise my position and my submissions as follows. On the 5th of July 2013, the judge was entitled, in the exercise of his discretion, to allow the prosecution to give notice of additional evidence that it wanted to call Earl Thompson, on the footing that the defence had been given reasonable notice that the prosecution wanted to call him. Now, no attack has actually been made on that decision, but one does have to understand the background to the impugned decision, and that's an important part of the background. The second submission I make is this. When the judge held that the prosecution should get Mr. Higgs along to answer questions, the reason he so held was simply because of Evans's submissions that she wanted to cross-examine him about whether the clothes and swabs that had been handed to him, according to his report, had been tested, and if not, why not? And the judge said, we need Higgs to deal with that because Thompson can't deal with it. He won't know the answer. And those were the reasons, indeed the only reasons at the time advanced, only specific reasons, advanced for requiring Higgs to attend rather than leaving everything to Thompson. And my lords, this is a very important point, if I may say with respect. There was no submission, either from Stubbs or from Evans, that they wanted to cross-examine Higgs, either A, for the purpose of challenging the report's evidence about the nature of the bullets and the guns, or B, for the purpose of challenging his tests or the results thereof. Nor did either of them explain why, and again this is important, why apart from the need to look at apart from the need to cross-examine about swabs and clothes, they needed to have Higgs rather than Thompson present to deal with the questions. And the judge repeatedly asked them, why do you need Higgs rather than Thompson to do this? And they just didn't answer. They didn't give a coherent answer. My third submission is this. When it turned out that the prosecution had not taken all reasonable steps to get hold of Higgs, the judge, consistently with his reasons for requiring Higgs to attend, edited out all those parts of the report which raised the question of whether or not tests had been carried out on the clothes and swabs, and allowed the rest in because, as he held, it was important. My fourth point is this: that, I say, was a perfectly proper exercise of his discretion, because first, section 120 of the Code, unlike provisions in the Evidence Act, does not make it a precondition of admitting an analyst's report that it can be put in evidence only if all reasonable steps have been taken to get the analyst there, but they haven't borne fruit. And I say, my lords, that is a conscious decision of the legislature. Second, I say it was a proper exercise of discretion because neither Ducil nor Evans explained, even at this point, why it was that apart from wanting Higgs to deal with the non-testing of clothes and swabs, they needed Higgs rather than Thompson to attend. They still didn't do that. And I also say, relatedly, there was no inconsistency between this ruling to allow the report in, but edited so as to exclude references to swabs on clothing and so on, between that ruling and his previous ruling that Higgs should come along to answer questions about the clothes and swabs. There's no inconsistency at all. My next submission is that nothing in the Constitution requires one to interpret section 120 as saying that in the circumstances of this case, Stubbs and Evans had an absolute right, without giving an explanation, to have Higgs as opposed to Thompson to attend. And I summarise the point in this way: the right given by the Constitution to cross-examine witnesses is not an absolute right, unlike the US Sixth Amendment, but an aspect of the right to a fair trial. And so that is always what matters. Was there a fair trial? Secondly, I say, a fair trial could easily have been had by Stubbs and indeed Stubbs's counsel and indeed Evans's, explaining why they needed Higgs rather than Thompson. There'd have been nothing unfair. There's nothing unfair in saying Mr. Ducil should have piped up and said what it was he wanted to cross-examine Higgs on, rather than Thompson. And I also say, on the facts of this case, a fair trial could always have been had in any event, with Mr. Higgs absent, simply by the defence asking for the guns to be handed over to them so they could carry out their own tests. But they just didn't do that. My lords, next, my sixth submission, which I'll elaborate on later if I may, is that in any event, there was no miscarriage of justice by admitting Higgs's report into evidence to the extent that it put in evidence of the tests that he personally had carried out, or indeed to the extent that it adduced evidence of his own opinion that the the casings were of the same type as the guns. I'll deal with that later. My lords, can I just first, I know it's a little bit laborious, just summarise the relevant facts chronologically, because it's very important, in my submission, to have a clear grasp of what the facts were in assessing whether or not the judge has gone wrong. Just starting off with the actual offence itself. In the early hours of the 29th of March, Ryan and Duncan, police officers, saw Stubbs, they say, place the .45 auto gun under a red Honda. And my lords, they both had worked in the firearms unit, and they both identified the gun. They said in their evidence it was a .45 auto. And my lords, the references of volume 4, 1351, lines 27 to 32, 1388, lines 10 to 15, and volume 4, 1426 to 1427, line 5. They were not challenged in their evidence about this being the make of the gun they saw Stubbs with. My lords, likewise, Burrows and Robinson also chased after Evans, and it was after they chased after him that Mr. Knowles, PC Knowles, came along and found the .375 silver or grey Desert Eagle Magnum in the sand. And my lords, we give the references for that in our case at page 3852, lines 17 to 385422. And my lords, they too both identified the gun as themselves, as the Desert Eagle Magnum gun. If I can just give you the references, Burroughs identifies it as, you would have called it a Desert Eagle. It was Magnum .357, bigger than mine. And he says that at volume 4, 1501, lines 20 to 29. And Robinson says, it was a big grey firearm, big, Desert Eagle design. I've never seen one like that before. My lords, I've missed out the reference, if I can come back with that. But anyway, you've got evidence as to the officers themselves who picked the guns up saying this is what they were. And there's no evidence, there's no challenge to that evidence. My lords, also, in the early hours of the 29th of March, PC Raleigh finds 6 casings, which appear to be from the 2 guns or to relate to the 2 guns, just outside the nightclub. And he marks them, and they're admitted into evidence, as KR1 to KR6. And KR1 is a .45 auto casing, and the other 5 are .356 magnums. And my lords, it's important in my submission to note that the casings are found just outside the club, which is where Campbell says he had seen the men coming out firing the shots. And that's at 2448, lines 8 to 18. So there's a match, if I can put it that way, between Campbell's evidence about where some shooting took place and where the casings are found. And one of those casings in relation to Stubbs is the .45. On the 30th of March, 1999, the day afterwards, in other words, Higgs carries out his test, and that's at 3844. And his report, it's not quite clear why, his report is dated the 18th of June, 1999. And my lords, I should go to that, because this is at the heart of the case. I think it's attached to one of our cases. It may be the case against Stubbs. In any event, it's I think I'm right in saying it's 3844. And you can see the date at the top, 18th of June. He names the 3 accused. On the 30th of March, I received from Knowles, the firearms unit, the following items. And you can see, first of all, there are the 2 guns, and you can see how he describes them. Magnum, Desert Eagle, and then 2 RK2. It's 2.357 Magnum cartridges. And then there's a .45 auto Llama pistol serial number and 2 .45 auto cartridges. My lords, you should ignore one of those cartridges because that was found in the body of the deceased, but that evidence was excluded. So that's why there's only a reference to 1 in the end. And then he has underneath that paragraphs 5, sorry, they're both excluded. Paragraphs 5 onwards, he identifies the casings. And you'll see how he identifies them. He actually says .45 auto casing and then .357 Magnum casing and so forth. To over the page, you get to KR6. And then after that, you get a number of other exhibits. And you'll see there that there are swabs from the hands of Mr. Davis, a blue and white jacket from Andrew Davis, multicolored trousers and so forth. And then you get to number 22, striped shirt from Clinton Evans, 3 of those, and then shirt from Germaine Poitier, another of the suspects. And then hand swabs from Clinton Evans, and 1 or 2 other items from Mr. Poitier. And then page 3846, my lords, you could ignore HG1 because that evidence was excluded. Item 5. Examination results. The submitted .45 auto pistol was examined and found to be in satisfactory condition. Serial number was obliterated by drilling. 2, the submitted .357 Magnum was examined and found to be in satisfactory mechanical condition. Reference to the clothing. Point 4, and my lords, this is the point that the defence wanted to ask about. No examinations were conducted on the articles of clothing that were submitted, likewise with 3 on Poitiers. Then 5, the submitted cartridges were examined and all components were intact. One of the .45 auto projectiles was seated further inside the cartridge than normal. And then 6, the submitted .45 auto casing was manufactured by Remington. The .357 Magnum casings, also by Remington. And then the submitted projectiles were examined and the following was revealed. I don't think we need trouble with, I think I'm right. Oh, so projectile A, KR1, that's from the .45, are both .45 caliber semi-automatic pistol bullets. They both have 6 lands and grooves with a right-hand twist. And he talks about the groove widths on those bullets. Then discussion conclusion, the submitted .45 auto pistol was test fire, found capable of chambering and discharging .45 auto bullet. And then similar set of conclusions is given in relation to .357 over page 2 and 3. And then point 4, laboratory comparisons were conducted. And it's the finding of this examiner that casing KR1, that's the .45 auto, and projectiles A and B, and A is one of the .357 Magnum, were all discharged by the submitted .45 Lama pistol, erased, and casings N through R, 2 to 6, sorry, that's the .357, were all discharged by the .357 pistol. Now, my lords, that's the nature of the report. At the preliminary inquiry, I should say, in December 1999, Higgs emigrates to the United States, and that seems to be common ground. The preliminary inquiry takes place in 2000, and Higgs does not give evidence at it. My lords, we know that from, I can just give you the reference, volume 5, 1911, 17 to 21. Nonetheless, and my lords, it's a slightly tangled story, but it's worth noting, Higgs's name does appear on the back of the indictment as a witness the prosecution proposed to call before the first trial. So his name is there, no doubt because they intend to put his report in, but his name is on the back of the indictment. And this gives rise to an issue at this trial. The first trial takes place in 2002, and Higgs's report is put in through a Mr. Dino DeVokes. And my lord, so far as we are aware, and that appears to be what the Court of Appeal for, no objection was taken by either Stubbs or by Evans's counsel to this course being taken, and DeVoe was indeed cross-examined. And my lords, we can see that from volume 5, 1892, line 29, to 1893, line 2. Now, my lords, on the 18th of October 2006, notice was filed that the prosecution intended to call Earl Thompson as an additional witness, because Thompson so far hadn't done anything. And that notice attaches Higgs's report. And my lords, the reference for that is at volume 5, 1882, to effectively 1884, line 8. But you can see that that's where that happens. The second trial then takes place in February 2007, and at that trial, Higgs's report is put in through Earl Thompson. Now, my lord, it is right, as Mr. Evans's case says, that Mr. Ducil objected, but the only point on which he objected was a chain of custody point. And my lords, it is just worth having a look, because it said that there was some objection by my learned friend Mr. Fitzgerald, by Mr. Ducil, but the only basis of the objection was chain of custody. And you get that from the attachment to Clinton Evans's case at 3941 to 3950. The passage begins at 3941. There's quite a lot of general submission at 3941, 31, 3942. The point being taken was that Mr. Ryan, I think Police Constable Ryan was supposed to be the person who handed it, in charge of the gun, the .45 auto, and yet there wasn't sufficient evidence of the chain of custody from Ryan to Higgs. That's the point being taken. And you can see that on page 3942. It becomes rather clearer on 3943. You can see about its line, the second line 4, that when there's no evidence to suggest that there's any cogence in the evidence, there's a difficulty in the nature of the evidence given by Ryan, Duncan, Gray, my lord, leave much to be desired. I've alluded to subsection 2 of section 20, which is the provision that says the court has a discretion to require oral evidence. My lord, there's a difficulty, but he carries on the next page, 3944. There's not a sufficient nexus between the items examined by Higgs and the 2 items said to be in possession of the officers. And if that's the case, the report is sort of pointless. He continues in the same vein, 3946, line 10, having regard to the nature of the evidence given by Gray and Ryan, my lord, and some other little things, if your lordship is necessary, I'll take my seat and move on. And then the prosecution replies that there's no ambiguity in the chain of custody point. And then the judge gives his ruling, I think, at page 3949, line 14. So, my lords, it's important, I submit, as part of the background, that there is no requirement for Higgs to attend to explain the ballistics aspect of his report at either trial by either of the defendants. The objections on other points, which are not relevant to this trial itself. My lords, at the second trial, both Mr. Ducille and Evans's then counsel cross-examined Thompson. The reference to that is at volume 5, 1893, 15 to 22. Now, my lords, before the third trial in 2013, notice of additional evidence was served, which by mistake said that the prosecution was intending to adduce evidence from a Sergeant Thompson, being a different Thompson from Earl Thompson, with a different report attached, confusingly. The trial then begins on the 10th of June. And one of the points that emerged was that the penal code had been amended in 2011, which required an amendment to the indictment. That appears to have led to people, for the first time, considering the witnesses named on the back of the indictment, and which was still the old indictment. My lords, you can see that at volume 1, at page 108 to 109. So, for instance, Marcian Scott was still on the back of the indictment, although he died in 2006. And my lords, Higgs also was on the back of the indictment. And you get that from volume 4, 1182 to page 11, line 11. So you've got what you might call an old indictment with old names. Now, the prosecution then says, like, you'll see why I explain this in a minute. The prosecution says it wants to remove Scott from the back of the indictment and also Higgs. Prosecution says, I want to get rid of Higgs as a witness on the back of the indictment. And that's at volume 4, 1182, line 11. But they also say they want to add Earl Thompson as an additional witness on the footing that we all know he's coming along anyway, because he gave evidence the last time round. And that's at volume 4, 1183. And also on the footing that a notice of additional evidence, as I've said earlier, had been filed on the 19th of October 2006, before the second trial. And that's at volume 4, 1183, lines 18 to 20. And he mentions he wants to add some other names. Now, at that point, Mr. Ducille says that he will be objecting to 2 out of the 3 names mentioned, possibly Thompson. And then Evans's counsel objects to the removal of the witnesses on the back of the indictment, including one of them, Mr. Pedro Bo, although she doesn't specifically mention. She does also appear, I should say, to object to Higgs being removed from the back of the indictment, although she calls him Ferguson. And, my lords, if I can just ask you to look at this reference. It's at volume 4, 1189, line 25. So you can see the genesis of this whole problem. Volume 4, 1189, line 25.
Sorry, which line, please?
25.
Thank you.
This is still at the beginning of the trial, and line 25. My lord, sorry, it's perhaps take it 1189 at line 10. Miss Farquharson, that's Evans's counsel.
Yes.
I would submit at this stage, I wish to point out that certain names, to remove those names, would certainly prejudice and damage our case, the defence case with respect to Evans. Certain witnesses, and Pedro Bow comes to mind. And then she also mentions, you'll see at line 18 to 19, ASP Albert Ferguson. Now, I understand that would have been the officer who would have dealt with the testing of the firearm. So actually, she's got muddled up. She obviously means Higgs. But she maintains Ferguson. And then Ducille, Mr. Ducille, as it were, helps out, because he's more familiar with that. He deals with forensic, which dealt with swabbing of my client, more where nothing was found, number terms of gunshot residue, the rest of the evidence. So again, Marshall and Scott and so on. So what she appears to be, what obviously of interest at this point to the defence, is they want Higgs to come along so they can ask him questions about the clothing and why was no test done on the clothing and so forth. That's their thinking at this point. Now, eventually, the Crown says there's no problem, we can get all these witnesses here anyway. But eventually, the judge refuses to allow the names to be removed from the back of the indictment. He does that in the same bundle at 1207. So he doesn't accede to the prosecution request to remove names from the back of the indictment. And you get that at 1207, 14 to 17. I don't need any argument on the case. I'm going to rule that the amendment, that is to say, to the back of the indictment, cannot be done without prejudice to the defendant. So he's alert to the point that the defendants want to have these witnesses come along to be cross-examined. But he then carries on, my lord, immediately after that. You'll see lines 17 to 22. That, however, that doesn't affect whether or not the prosecution should be allowed to adduce notice to adduce further evidence. Now, my lord, that is the background to the later dispute about, first of all, allowing Thompson's evidence to come in, and secondly, as to whether Higgs should be called or not. Now, before that happens, my lords, on the 13th of June, 2013, at the trial, Raleigh gives evidence about where he found the casings, and those casings are admitted into evidence, as I've said, as KR1 to 6. My lords, that's at volume 4, 1233 onwards. There's no challenge to that. On the 18th of June, Ryan and Duncan give their evidence about Stubbs putting the gun, black gun, under the red Honda. There was a general challenge, obviously, to that, but there's no challenge to the gun being a .45 gun. It's a challenge generally. On the 18th and 19th of June, Burrows and Robinson give evidence about arresting Evans and seeing him with a gun, and the gun, the .357 Magnum, is admitted as an exhibit. And then on the 5th of July, evidence is adduced from Phyllis Smith to prove the chain of custody. And that's from the officers who found it to Higgs. And that's volume 5, 1880, 1858 to 1868. And that wasn't materially challenged. On the 5th of July, the prosecution say they want to call Inspector Thompson to adduce Higgs's report into evidence. Now, my lords, the first objection, this is why by the defendants is that the prosecution should not be allowed to adduce notes of additional evidence, to put Thompson in evidence, because they hadn't been given reasonable notice. That's what they said. And that you get that at volume 5 at 1868. That's where they make the objection. We haven't had sufficient notice of Thompson. To which the prosecution reply, not entirely surprisingly, how can you say that with a straight face? Because Thompson actually adduced Higgs's evidence at the second trial and was cross-examined on it. Now, if I can ask you now to turn to page 1876 in volume 5. At line 14. And my lords, at this point, we are still on the question about whether the prosecution should be allowed to give notice of additional evidence, bring Thompson in. And I think at 9 to 16 of 1876, however, my lord, subsection 2, obviously, that's obviously section 120, subsection 2, obviously contemplates Article 20 of the Constitution. And insofar as the serious nature of this matter is concerned, my lord, I seek my lord to make application under subsection 2 of 120 to have Mr. Higgs present, because there are certain questions that I personally have to ask him in relation to my client. I don't know if anybody else. So at that point, he says, I've got certain questions without identifying what it is. Evans's counsel objects on the basis that she was rather misled. She didn't realise Thompson was going to turn up. And that's at 1879, lines 12 to 25. She says, I haven't been given reasonable notice. And then she continues at the end of the page on 1879, on behalf of Clinton Evans, I'd submit to you, this is not reasonable notice. It's improper. Bear in mind as well that the issue we're dealing with, my lord, is quite significant. We're talking about testing projectiles, swabs, the gunpowder residue, which is quite crucial to the issue. That is before the jury to decide. So it's quite significant. I humbly submit, my lord, that providing this notice of additional evidence to me in this fashion and then correcting it 4 days before calling the person is certainly not reasonable. And then she says, I think it lines, that Miss Ferguson continues at lines 22. My lord, I would also join. I note that Officer Higgs is listed on the back of the information. He's 18th on the back. We certainly wish to speak to him, my lord, with respect to what testing and analysis, what findings he may or may not have had with respect to the clothing of Clinton Evans and any swabs. Because I note from this witness that just came, Officer Smith, she said she preserved certain items for testing, which would have been for gunpowder residue. So this is what the interest of Evans is at this point. His report, in looking at it, doesn't address what findings. He accepts he received them on page 2. He speaks to receiving them. However, when one looks at the examination results and conclusions, there's no mention, no examinations were conducted. So I submit it's important for him to come because these items are given to him for testing. And he says he conducted examinations on them. At number 4 of his report at page 3, he says that no examinations were conducted on the articles of clothing. As I've indicated, this is crucial. The Crown is leading a case that my client would have been on the scene. Then she continues in the same vein. Here is certain physical evidence, which I want to ask questions about. And then she says near the foot of the page, about line 26, he's criticised the Crown for wanting to put in the good bit of the report without having to Higgs there to answer other questions. I think the Crown, I guess, find it advantageous to them to just have a Sergeant Thompson come and read a report when there are certain probing questions that need to be answered, my lord, that he clearly cannot answer because this report doesn't speak to it. Why things were not tested, what happened, what were the results if tests were done, and over the page. And so, my lord, I would humbly submit it would certainly be unfair for Sergeant Thompson to come and purportedly regurgitate and read this report in the present condition or the state that it's in. Those are my submissions. And then to similar effect, I think Mr. Cargill basically says, I also want to know why the clothes weren't examined. That's lines 11 to 12, 1882. And then the prosecution reply, basically saying reasonable notice was given, and the science hasn't changed since Higgs gave his report. And then at page 1887, in the course of the prosecution's submissions, at line 29, the judge, which was still on the notice of additional evidence, asked at line 29, I'm asking the prosecution whether or not the notice of extra evidence or additional evidence complies with section 166, that is, of the criminal code. And then Mr. Armbruster says, the prosecutor says, yes, it does. And in fact, he says the evidence goes further than necessary, and so forth. There is then an interlude, my lord, when Evans's counsel, who hadn't appeared at the second trial, denies that it was ever served on, the notice was ever served on her, to which the prosecution says, well, it was served on your client, right? Because Thompson gave evidence at the previous trial. I should say Mr. Ducille also takes the point that section 166 of the code wasn't complied with, but that's an immaterial point, which the judge dismisses that.
Well, shall we take a break now, Mr. Knox?
Yes, sir.
5 minutes.
Yes.
Thank you very much. Now, Mr. Knox.
Hello, my lord. Hello, my lords.
I think we're having a little interference on the line. Try again, Mr. Knox, I think.
Oh, no.
We still can't hear you, Mr. Knox.
I can hear you.
You're right, we can hear you now.
I'm sorry, my lord.
No, not at all. No apologies.
My lords, I was just going to take you to the first ruling on the notice of additional evidence point by the judge, which is at volume 5, 1893, lines 15 to 28. Just ask you briefly to look at that to yourself. He simply says, well, I'm satisfied notice was given, because how could Thompson have otherwise given evidence in 2007? And then after the ruling, or at least part way through the ruling, Ms. Farquharson at the foot of 1893 says, with respect to what we indicated wishing to cross-examine Mr. Terence Higgs. And the judge said, that's a different matter. So in other words, he's dividing the question of additional evidence from Thompson from the question of whether Higgs should come along or not. And he then, over the page at 1894, he essentially says, I don't see why Higgs shouldn't come along. I'm going to exercise my discretion under section 120 to let Higgs give his evidence, or rather put his report in, under section 120. In particular, you can see that's his line of thinking from lines 11 to 21, and indeed 25.
Yes.
He says, I've looked at this section again and again, basically. Can't see why I can't let it in on the face of it. And so at that point, as things stand, he's suggesting Higgs isn't going to attend. Now, at 1895, line 16, line 7, you can see the court says, I'm not going to allow to make any order for Mr. Higgs to come to be cross-examined. And then Mr. Cargill says, even though his name is on the witness list. Now, at this point, the defence, so to speak, resume their attack and say why it is that they want Mr. Higgs to come along, and so the judge does eventually reconsider it, and Mr. Ducille comes in halfway down the page. I would like to have Higgs for cross-examination because Thompson cannot in any way assist in my case. He says there are certain essentials I need to elicit from Mr. Higgs, and he continues in the same vein over until you get to page 1896, line 12. But what he doesn't do is say what it is that Higgs can deal with, which Thompson can't. He just says, I want Higgs, basically. And then, second half of 1896, the court introduces this point at line 18, apart from the chain of custody argument. So the chain of custody argument emerges at this point again. And then Mr. Ducille says, apart from that, we still need Higgs, if we're going there. And then he continues in what you might call fairly general terms to say, I'm entitled to have him here under subsection 2, and says I'm going to make an application otherwise. And then the court says at line 9 on 1897, if you're going to make an application before me like that to say it's in the interest of justice that you were called, then you need to be more wholesome. You're saying you need Mr. Higgs, that's not sufficient. And my lord's pausing there for a moment. In one sense, this is the heart of the case. Was it sufficient? And my learned friend says, Mr. Ducille didn't have to go any further. That was enough. I say, no. It's a matter of discretion for the judge to call Higgs or not, and he is entitled to say, give me a reason. Otherwise, we're just calling someone over from the United States or whatever it is for what might be a completely futile exercise. And so really, it's at this point you get to what I might call the heart of the case. And the judge's thinking is, I'm not prepared just to have Higgs here, just because you say you want him. Then very importantly, lines 16 to 17, because this really is the point, which is never answered properly, I say. The court, what is Mr. Higgs going to provide that Mr. Thompson cannot? Mr. Ducille, he will provide certain things because he is the one who did the examination of the items, and there are certain essentials. And Mr. Thompson can't speak to that? No, my lord, without speaking further. And there are certain things which Mr. Higgs can answer, which Mr. Thompson is incapable of. And the court says that alone isn't sufficient. And then Mr. Ducille reverts to the notice of additional evidence not being in proper form. He sort of backtracks a little. The court says, well, I've read that. And then over the page, 1898, you get what you might call the continued debate. The court. What I want to hear from you, Mr. Ducille, is in relation to this issue of what it is that Mr. Higgs can provide that Mr. Thompson cannot. Mr. Ducille, that will be showing my hand in terms of what I propose to cross-examine about. I can't do that in the earshot of the prosecution, my lord. I can't do that in the earshot of the prosecution. So you get this sort of standoff, which in a sense is the point your lordships now have to decide. Was the judge entitled to say, give me a reason, or was Mr. Ducille entitled to stand on his rights, or as he says, his rights, and say, I'm not going to tell you. And then the court, subsection 2 is very clear. This is line 12 of 1898. The court on its own motion or where it appears desirable. And then Ducille, if Mr. Higgs was not essential to their case, they would want to have his report tendered. My submission is this, that seeing Mr. Higgs is so essential to their case and Mr. Higgs is essential to my defence, I wish to cross-examine him. My learned friend made mention of the fact that he's no longer on the force. That's neither here nor there. At the time he did his report, he was a member of the force, and so he's capable of giving evidence. So it's neither here nor there that he wasn't, and so on. And the judge says, well, going beyond that, you're saying that apart from the contents of the report, you require him for cross-examination. Well, once again, there are certain things preliminary to his report. So we're now getting a different line of reasoning. These are things which are preliminary to his report. So, my lord, I wish to cross-examine him. Mr. Thompson will only be giving evidence in vacuo. My learned friend sought to give evidence as if he's a scientist, and so on. My lord, we know that Higgs has done certain things. Who is to say, and this cannot put us in the realm of inspection, that Mr. Thompson would not do things differently? Difficult, must be different. We are not here to speculate. I wish to see where Mr. Higgs is, bearing in mind my learned friend Miss Farquharson Seymour listed that certain items had been given to Mr. Higgs for which no findings were given. What's the reason for that? Mr. Thompson cannot speak for that. So, my lord, there are certain things essential, and my lord, the defence should not really be fighting so hard. The court, I'm trying to understand your point. I have to know, apart from her point about the evidence in relation to the clothing, so he's giving an opportunity now, Mr. Ducil, my lord, the fact that I wish to cross-examine Mr. Higgs without more is enough. Because, my lord, if a witness is going to come and give evidence and wasn't to cross-examine him, what's the sense of having a trial? The court says, then what's the point of section 120? That's when things are not contentious. The court says, I didn't see that there. And Mr. Ducil says we have a contention. So it's all contentious. And then over the page, 1900, he repeats the point at line 5. There are certain contentions preliminary to Mr. Higgs's finding. Court, so let me know what they are, so I can decide. Mr. Ducil, I don't think we should go that far. The court says, that's how I'm dealing with it, for me to agree with your application to try to get Mr. Higgs here. So he's giving him every opportunity. And then, Mr. Ducil, I have given you one. We don't need any more than that, my lord. There are swabs, there are clothing, because, my lord, there are some other things. So, my lord, everything takes you right back to Van Stocks, and your lordship rightly observed that you're a referee and so on. And the judge, you're making an application that, notwithstanding subsection 1, the court may, if it appears desirable and so on, I need to know, what I need to know is what I'm going to decide. And Mr. Ducil, really, we land up going round in circles.
Well, I think we've probably had enough of that, haven't we?
I think so, Nigel, but you have the point. Now, what eventually happens is that the judge does make a ruling after Evans reiterates her point. Evans's counsel, I should say, reiterates, Mr. Cargill for Davis, 1904, he basically says, this is 1904 lines 16 to 29, he basically says there are certain pieces of clothing he wants to have examined. So Davis is coming in on the clothing point. And then Evans's counsel at 1906 to 1907, she basically says, well, I want to cross-examine about the clothing and the swabs. And that's all she's saying at this point. And then my lord, Mr. Ducil comes in again at 1908 at lines 6 to 20. Again, it would seem reiterating that his concern, or giving his point, that what he wants to do is to look at the clothing and things like that. And he also says certain chains haven't been established. There's been no foundation laid to put these things in evidence. That's 6 to 20. And that's why I want to have viva voce evidence.
Right.
Now, so my lord, what obviously I take out of that is that at no point does he say the most simple of all things, I want to cross-examine him about how he did his tests. I want to cross-examine him about his opinion about the bullets, or the casings rather, being of the same size on the face of it as the guns. I mean, these are obvious points to make, because I don't see it in the report. He just doesn't give any serious reason. And my lords, one can see tactically the problem he had. Because as soon as he says, well, I want to see whether I want to know more about the tests, the obvious riposte from the prosecution is, well, we've got everything here. If you like, you can carry out your own test if you say you're prejudiced. Now, the last thing the defence want is to be put in that corner. And so I submit that you cannot just assume this was some sort of oversight on Mr. Ducil's or Evans's counsel's part. They studiously avoid giving what you might call the reason they now say they wanted. In other words, to test the ballistics aspect of the report. In any event, my lords, the judge then makes his ruling at 1913, line 10. This is after the prosecution has essentially said, we don't really need Higgs here at all. Thompson can deal with everything. And you can see at line 10, unfortunately, on 1913, unfortunately, I agree with Miss Farquharson-Seymour. There is some material in here that would require his presentation for cross-examination. I emphasize some material. And then the prosecutor tries to get him to change his mind. Court, what you are telling me when it says no examination of so-and-so or in relation to the swabs for her client, I mean, unless the other person, Mr. Thompson, was there at the time, and part of the conduct of this, it seems that the only person who would know why he didn't do it was the person who did it. And it's speculation to say that because of lack of equipment or malfunctioning equipment or whatever, and the prosecutor agrees, and then at the foot of the page, line 30, I'm saying that I agree with everything in relation to 166, that's the notice of additional evidence, and 120. This is an application under subsection 2, but notwithstanding all of that, if a party applies where it assists peers on the interest of justice, on the application of any party, and she has applied, she is obviously evidence's counsel for a witness to be available to give evidence, and that's what I'm dealing with. So I'm saying that looking on this, these are all things, these things that were examined by Mr. Thompson can come and say, yes, this was done, and so, and speak to the science. So in other words, Thompson can deal with the actual things examined, and he can speak to the science behind it. But when it comes and says no examination of a particular item that relates to her client, there is no reason for him to say that reason is a good one or a bad one or whatever it is. That's the end of it. That's the sentence. How can Thompson come and say what reason Higgs didn't examine something? That's the problem I'm having. I'm not with all of the items to examine, that's fine. And it sets out his conclusion. And then the court, he can come, Mr. Thompson can come and speak in relation to many of the items. But it's speculative for him to come and say why Mr. Higgs didn't examine something. All of the other conclusions are fine, and so forth. And so, my lords, that's the judge's ruling. And then page 1915, he continues, the judge continues, but that's fine. I'm saying to you under subsection 2, if it's in the interest of justice to have the person attend and give evidence, then that's where we're at. Because that is why I asked counsel to give me a reason why. It's not just a simple matter of saying, I want it for cross-examination. They have to justify it, and counsel has shown me the sections here related to her client, but she said she wants explained. That's my difficulty. And then at the foot of the page, Mr. Armbrister says, well, we're going to have to get our evidence together to explain why it'll be difficult to get Mr. Higgs along. But you can see over the page, 1916, the judge concludes at line 18, I believe it's in the interest of justice to call the analyst himself. Now, my lords, the obvious point I make about all this is that the judge's ruling here is simply limited to the need to get Higgs along to deal with the things that weren't examined. And my lords, this is re-emphasised at page 1919 by Miss Farquharson, Evans, coming back in. She wants to make clear that she wants Higgs to come along, not just to deal with the clothing, but also the testing of the swabs, or rather, whether or not it was done. That's 1916, 11 to 16. Now, my lords, evidence is then given of the attempts to get hold of Higgs about, I think, the evidence which I've just been talking about was given, or this debate, I think, took place on the 5th of July. The evidence about the prosecution's attempts to get Higgs was given on the 13th of July. Nothing happened between times. And my lords, we summarise the effect of that evidence, paragraphs 53 to 54 of our written case about the attempts to get hold of Higgs. And my lords, it's important to note 2 points. He was obviously reluctant to come along. There were 11 telephone calls he didn't take any notice of. And he didn't reply to emails, save once when he did speak on the phone, and he expressed concern about 2 things. First is the lack of a Bahamas passport. So he's not too keen on coming to Bahamas for that reason. But secondly, and I quote, he expressed a concern about his security. And you get that, my lords, from volume 6, 2056, lines 10 to 16. So Higgs is on any footing.
Sorry, give me that reference again, please.
Volume 6, page 2056, lines 10 to 16. So Higgs has two concerns, and he's obviously being different. I mean, he's just taking no notes of telephone calls. Now, the problem the prosecution had, and they obviously misunderstood what the judge wanted, all those attempts to get hold of Higgs had preceded the hearing on the 5th of July. They'd taken place in late June, early July. The prosecution obviously thought all we have to do is to sort of give evidence of what our attempts to get hold of Higgs. And the prosecution didn't make any attempt after the 5th of July, that's say the judge's ruling, didn't make any renewed attempts to get hold of Higgs. So that was one criticism of the prosecution. The other, sorry.
Yes, I think that last reference may not be correct. 25th, the concern about security. Perhaps you could help us at another point on that.
My lord, I'm obliged. I shall come back, but I saw it this morning, so I'm sure it's there.
I'm sure it's there somewhere, but it'll be helpful to know where. Thank you.
Well, there is a fairly cryptic reference to security at lines 13 and 14 on 2056, but it doesn't elaborate on it.
Yes, I think, my lord, forgive me, in that case, I will double check anyway. I think it's in contradistinction to the lack of a passport.
Yes. Well, the answer is he had two issues: the lack of an American passport, which I offer to since the State Department issues American passport to facilitate, and also he expresses concern about his security. Yes,
my lord, and that refers back to another conversation as well. My lord, perhaps I can get back after lunch.
Yes, certainly. Yeah.
But he's obviously not. This is not. We're not talking here about a witness who's just around the corner. He's miles away, and he's obviously being difficult on any footing. But the criticism is the prosecution don't think about, and this is quite clear, they don't consider the possibility of getting a video conference for him. And that is why the judge holds, essentially, that not all reasonable steps were taken to get hold of him. And my lord, you will see the judge's decision on the point is at 20, I think, volume 6 now, at 21:43. And if I can ask you to look at that, because it explains, or rather reiterates, why he'd wanted Higgs to come along in the first place. At 21:43, and you have quite a long decision. It begins at line 20. I'm not going to ask you to read all of it, but just to note one or two points. And the judge prefaces his judgment with, on the 5th of July, Miss Farquharson submitted before me, she required the presence of Higgs for cross-examination. She argued that the report gave no results for reasons for the failure to examine the items of clothing of all the 6 swabs of Clinton Evans for testing. She also argued that notes of additional evidence by Thompson gives no indication that he was present during the examination in 1999 to enable him to comment on why those tests weren't performed. In any event, he wouldn't be able to comment on what's not in the report. And then, so he goes on to explain the background to his previous decision. And then about halfway down on 21:44, line 17, the court is of the view that there was some material in the report for which the assistance of Terence Higgs would be required to give all evidence. Unless Sergeant Thompson was present, he would be unable to comment on these matters. And then he goes on to deal with section 120. And then he goes on to discuss the evidence and say, well, it's not good enough. And in particular, 21:45, line 2 onwards, he points out that the prosecution didn't consider a video link. And then 21:46, lines 11 to 13, I think this is right, he makes a ruling that not all reasonable steps have been taken to provide for the attendance. Sorry, it's lines 9 to 11. Suffice it to say that not all reasonable steps were taken to provide the attendance of Terence Higgs. And my lords, what he then does is he goes on to explain what he's going to do in the light of this. And so what he's going to do is to remove all those bits of the report which refer to the swabs and the clothing, so as to remove any potential prejudice that they might create in the mind of the jury. And so therefore, there would be, so to speak, you just have the ballistics aspect of the report left totally on its own, without all the other bits of evidence. And you see him do that from 2146, and it goes on until, I think, 2148, line 8. And then the nub of it is at 2147, line 20. But having all the circumstances under section 178 of the Evidence Act, I exclude all evidence from the forensic report of Terence Higgs, which makes reference to the disputed items. That is the items which were not tested by him and for which no results were provided, and the testimony of Thompson is hereby restricted accordingly. It's my view that the admission of the report of everything would have such an adverse effect on the fairness of the proceedings that the parts I've mentioned should be edited, and the forensic report is to be edited accordingly. And then there's quite a bit of discussion after that about exactly how the editing should take place. And then he makes one or two other rulings which are not material to the point. Now, in my respectful submission, there is nothing wrong in the way the judge has approached the matter. If I can just summarize my submissions, because this is the crucial ruling, this is the bit that matters. First of all, and I make this as I submit an important point of law, the law, or rather section 120, does not require that the analyst's report must be excluded if the prosecution has failed to take all reasonable steps to get him to attend. And my lords, I would like just to look at section 120 and then compare it with section 66 of the Evidence Act to see this is obviously a conscious decision, and then to explain why it makes sense that you don't have the restriction my learned friend argues for. And the section 120 is in bundle 1 of the authorities at page tab 1, I think. Sorry, bundle 1, page 4007. My lords, forgive me, it's at tab, I think, 4. 4006 it begins. 120, any document purporting to be a survey for public purposes within the meaning of the Land Surveyors Act, or B, a report made under the hand of an analyst on any matter or thing duly submitted to him for examination and report, shall be receivable in any criminal proceedings in any court as evidence of any matter or thing contained therein relating to the survey or examination as the case may be. My lords, you'll note from the side note that this appears to have been introduced in 1987. And then subsection 2, notwithstanding subsection 1, the court may, of its own motion, or where it appears desirable in the interest of justice, on the application of any party to the proceedings, require the person who did the survey or the analyst to attend before the court and give evidence. And then subsection 3 goes on to provide for post-mortems. Subsection 4 defines analyst. In this section, the expression analyst means a person employed in the public service as an analyst, a firearms examiner, a ballistics expert, firearms technician, or radiologist, all subject to him being designated, such and so forth. And then subsection 5, the court may assume for the purpose of proceedings that the signature on any such document is genuine without further evidence on the point, and that the person preparing and signing it held the qualification of office which he professed to hold. And then subsection 6, which, my lords, appears to have been introduced a couple of years later, And I must admit, on the face of it, it's not totally clear how it's meant to fit in with subsection 1, but it may not matter very much. And notwithstanding anything to the contrary, in this or any other law, any document purporting to be a report of an analysis, test, or examination carried out by a person in the public service or capacity of an analyst, chemist, laboratory technician, or medical practitioner, shall be receivable without proof of the signature, qualification, employment, or office of the person by whom the report purports to be issued in any proceedings of a criminal nature as prima facie evidence of the results of the analysis. My lords, whether that's intended to draw a distinction between evidence and prima facie evidence, as you see in subsection 1 and subsection 6, or whether it's intended to address the point that, well, what if there's no signature on the document, is not entirely clear. But in any event, I submit it doesn't make any particular difference to the facts of this case. I submit that the prima facie position under this statute is that a report without more is admissible in evidence. And the only exclusion is if it's in the interests of justice to exclude it. There is no automatic exclusion if, in the event that, for instance, the defence want the analyst to turn up and then the prosecution doesn't make all reasonable attempts to get him there. That, I submit, is to be contrasted with the Evidence Act, which doesn't apply, or not specifically apply, to analysts. And you can see that, I think, in the next tab along, at section 66, page 1420, my lords, I may have given you a bad reference. 1426 is the, sorry, 1423, section 39. You can see section 39 provides that hearsay evidence shall not be omitted in evidence. And then gives certain exceptions for when it can be omitted in evidence.
Sorry, you said 1423.
Sorry, 4023.
Oh, I see. Sorry.
Forgive me, my lord.
That's all right.
You have
yes.
a provision for exceptions allowing hearsay evidence in. So that's obviously quite restrictive. Only in certain circumstances can you generally have evidence coming into hearsay evidence coming in. My lords, I just draw your attention to that, but the point there is it's restrictive. There's a restrictive regime generally for hearsay evidence. More importantly, documentary evidence in section 66 at page 4026. Subject to section 67, a statement in a document shall be admissible in any criminal proceedings as evidence of any fact stated therein, of which direct oral evidence would be admissible, if A, the document forms part of a record, so forth, and then certain conditions are satisfied, applying to the person who compiled it. And they are then set out in subsection 2. Now, my lords, one of those conditions you'll notice is subsection 2b. The condition is that all reasonable steps have been taken to identify the person that supplied the information, but that he cannot be identified, and that the identity of the person who supplied the information being known, all reasonable steps have been taken to find him, but he cannot be found. So in this what you might call rather wider range of evidence, there is a restriction of the type that my learned friend contends for. And then also, subsection 3 over the page, it also gives a specific consideration the court is to take into account in the interest of justice. This is 4b, not 3, subsection 4b. The court is obliged to consider the likelihood that the accused will be prejudiced by the admission in evidence. In the absence of the person who supplied the information. So it's a much more restrictive regime in relation to documentary evidence generally. So what I submit you get is what you might call evidence of an analyst is given what you might call more favourable treatment or report from an analyst is given more favourable treatment than general documentary evidence generally, and the only restriction is the interest of justice. Now, my lords, I submit there's good reason for this. First of all, analysts are not witnesses in the classic sense of the word, but independent experts who are looking at material given to them only after the event for a specific purpose. For instance, like in this case, or it could be, for instance, someone who has to analyse whether or not certain material consists of illegal drugs and so on and so forth. They are carrying this out, so to speak, in on their own as independent of prosecution, and also it will very often be the case, as I submit here, that the material which is open to the analyst will also be available to the other side, to the defence as well. So there's good reason for drawing a distinction. Secondly, my lords, you can normally assume that analysts will be using equipment of some sort as part of their testing. And in my submission, you can normally assume that the equipment the analysts have will be working properly, so as to record the results of tests properly. Thirdly, my lords, this is a point made by the American authorities. Often, analysts' reports will be put together from a number of different sources. And it would often be very difficult or inconvenient to have to call everyone involved in the making of the report. In real life, most analysts' reports are what you might call combined efforts. And so I respectfully submit one can see why the legislature has decided to give what you might call rather more favourable treatment to analysts' reports than to other types of documentary evidence. They're likely to be more trustworthy, they're independent. Normally the defence can have a look at the same material anyway. Now, in my submission too, nothing in the Constitution alters this. And my lords, if one goes to volume 1, page 3981, section 20, just to look at the constitutional provision. This is volume 1, tab 1, 3981. My lords, you've been shown this by Mr. My lord, forgive me, yes.
Yes, Lord Burrows.
Just before we move on, has anybody examined this question that you're looking at, the relationship between section 66 and section 120? I mean, is there any academic work? Is there any case law? Are there any? Has anybody looked at this? I mean, you're giving us reasons why you think it might be that there is good reason to distinguish them, but has anybody objectively looked at this?
Oh, my lord, objectively, well, my lords, it has been meant. I think I'm right in saying in the recent decision of the Privy Council, which my Lord Hampden gave a judgment in, there was a reference was made, I think, to section 120 and also to section 66 of the Evidence Act, but it wasn't, as it were, critical to the actual decision. My lords, apart from that decision, which I can, after lunch, maybe I can dig up, I'm not aware of any discussion of this, either in the authorities or in the any academic articles.
Thank you very much.
I will dig up the reference in Bain after lunch, if I may. Because it does, I think, talk about there is some correlation between the two. But my lords, you have my point. I say one can see why, with analysts who put them in what you might call a different category from the run-of-the-mill document. That's what it comes to. My lords, I say nothing in the Constitution alters this. I think in page 3981, now, my lord, I would accept that if you look at the words of the Constitution on their own, it looks as if, and I must admit, when I first looked at this case, I thought, goodness, look, section 20 is a bit unhelpful, because it appears to be expressed in absolute terms. That is to say, if you look at section 20 subsection 2, every person, this is 3981, every person who is charged with a criminal offence and who shall be presumed innocent and then be told of the offence and so forth, given adequate time, permitted to defend himself, And then E, shall be afforded facilities to examine in person or by his legal representative the witnesses called by the prosecution before the court, and to obtain the attendance and carry out the examination of witnesses to testify on his behalf before the court on the same conditions as those applying to the witnesses called by the prosecution. And then F is interpreters, and then G, in certain circumstances, right to trial by jury. And then he mustn't take place without it. Now, my lords, if you look to those words literally, one could see that there's a case for saying that an analyst is a witness. My lords, I would dispute that, but never mind about that for the moment. An analyst is a witness, and this is just a straightforward absolute right. And my lords, there is no doubt that in the United States, I think it's Amendment 6, is the confrontation clause, the United States Supreme Court has interpreted what you might call the equivalent of this as absolute. You've got this right, full stop. And it's not what you might call, it's not a mere aspect of the fair trial right. Well, that's one way of looking at it, which would be notionally how the US Supreme Court looks at it. The other way of looking at it is the way the Privy Council has looked at it, and the way the Supreme Court looked at the equivalent provision in Article 6 of the Convention on Human Rights, which is to say that this right, the right to examine, is merely an aspect of the right to a fair trial. And as long as the trial is fair, then this right can be derogated from, or this apparently abstract right, this apparently absolute right can be derogated from. My submission is this is not an absolute right. It is the only question which has to be considered in the light of this provision is whether or not the judge's decision was one which was consistent with a fair trial.
Given that the judge accepted Ms. Farquharson's submission that it was necessary for Mr. Higgs to attend so that she could cross-examine along the lines that she had indicated, how can it be said that it's not against the interest of justice to decide not to require him to attend?
Because, my lord, and this is what the judge did, and it seems without actually her objecting, he removed all those parts of the report which were to do with the swabs and the clothes, and indeed other parts to deal with the bullets which have been recovered from the deceased body. So the report that goes in is in truncated form. And that's what the judge does to meet the point that Higgs can't come along. Because if you left, I think the reasoning being, if you left those other bits in, the jury would be wondering, what's all that about? So the judge takes it all out.
Yes, but she wanted to cross-examine on the reasons that he didn't conduct a forensic examination of certain items. Isn't that right?
Yes, my lord.
Merely deleting or excising parts of the statement, it doesn't answer that question, does it?
Well, it doesn't, my lord, but on the other hand, it certainly removes any prejudice which could result from having those passages left in. And secondly, my lords, one asks, overall, what is the prejudice to the accused? They can always make the point that there was no testing anyway. There's no evidence that there was any testing of the clothing and so on and so forth. So they can always make what you might call the point that there doesn't seem to be much evidence that we were involved in the shooting, because there wasn't any evidence of firearms and so forth found on our guns. The prosecution hadn't alleged that. But my lords, I accept that a point, which is, so to speak, gone because Higgs doesn't turn up, is the point that the defence might have wanted to make, that for some reason Higgs didn't carry out tests on the swabs and the clothing. But one asks rhetorically, where would that actually have taken them on the facts of the case? It's not suggested, in fact, that would have made a difference to the outcome of the trial.
Well, let's suppose Mr. Higgs conceded in cross-examination that one would have expected that had they been involved in the shooting, that there would be deposits on the clothing, which would have revealed exposure to, for instance, gun residues.
Yes.
And that was not conducted. Those tests were not conducted. Would it not have been possible for the defense to say to the jury, well, certain vital, potentially vital evidence was ignored here, and you must take that into account when trying to assess whether or not the guilt of these accused is established beyond reasonable doubt?
My lords, I would accept that as possibly what you might have said, but can I answer it in this way? They could say that anyway. Quite simply, they could say, we know these men were taken in immediately after the event. Well, certainly evidence was. I think I'm right in saying Stubbs was taken in by the 30th. And we know that there's no suggestion that any residue was found on their clothing.
Mm-hmm.
Members of the jury take that into account. My lords, I can see this point. As an advocate, one would say, well, I'd quite like to have Higgs backing me up on that. So you get him, nothing like getting a witness to give a sort of helpful answer. Of course, if he gives one. But my lords, the basic point that you put to me as one that could have been made was there to be made in any event. And so I say it is not one which has caused a substantial miscarriage of justice. And the judge did the best he could in the circumstances. My lords, we're on the point at the moment of how the judge should have exercised his discretion, because he yes.
Just on that particular point, Mr. Knox, is that a question that could have been put to Mr. Thompson?
Well, I would have. Well, he might not have been able to say why no tests.
No, but whether is likely to find residue on clothing.
Yes.
Yes. Well, certainly that could have been put to him. Yes.
Yeah.
But the judge's reasoning, he, I'm not sure if I took you to this, his reasoning, of course, is that this is important evidence and that I'm not here to punish the prosecution. And my lords, the question is not, and it's obvious, but it's worth making, my lords, is not whether the judge was bound to admit the evidence, but whether the judge went wrong in principle or in law in allowing the report to go in through Thompson. And in my submission, there's nothing wrong in that at all. It was not a perfect situation to find himself in, but looking at the overall interest of justice, and that is the test. The overall interest of justice in my submission did require the report to go in, because there wasn't, in fact, going to be much prejudice, if any, to the defendants by allowing it in, with the right to cross-examine Thompson. And perhaps most importantly of all, they hadn't identified what the prejudice was going to be if that happened, apart from the point my lord takes, that, of course, they lost the opportunity of cross-examining Higgs personally about the absence of tests.
Yes.
My lords, can I just take you, well, can I just make 2 points? One is a point of law, which I won't take you to the authority, and the other is a point of law, which I do want to take you to an authority on, because really it's the central authority on the legal point in the case. The first point is this. The Constitution of Bahamas, in my submission, in the provisions we're looking at, is merely seeking to reflect the common law, and it's not, so to speak, seeking to alter the common law or to make it rigid, so that if there was no right to admit an analyst's report before the Constitution, then it follows that this clause you see in section 20 ousts or makes unlawful any subsequent provision, such as section 120. And the authority for that is Vincent, a decision of the board, which is that I don't think it's from the Bahamas, I think from Jamaica, but on a virtually identical provision. Tab 4, sorry, bundle 4 of the authorities, tab 67, 5310. And that's where Vincent, basically, I think it's a decision, judgment of Lord Wolf. He says these provisions should be read as reflecting the common law, rather than intending, so to speak, to produce a new code or new absolute code. The second decision, which, my lord, it may be better if I come to after lunch, is the decision of the board in Grant on I think, virtually identical provision from Jamaica, a decision of Lord Bingham, where he goes through the jurisprudence of the United States, to a certain extent, the European Court of Human Rights and the Constitution itself, to make the point that this provision here, in particular, the right to cross-examine, is not an absolute right, but merely an aspect of the right to a fair trial. And it's quite a detailed judgment where he explains, where he looks at the various competing ways of looking at this and makes the point that this right is not to be interpreted like the Sixth Amendment of the United States Constitution. My lords, I can start getting into it now, but I see the time is 12, well,
yes,
30
well,
minutes.
Yes. Okay, we'll sit again at 2 o'clock. Thank you very much indeed.
Thank you, my lord.